I'm Mark Palmer, Chief Counsel at the Commission. I hope you're ready to dive into an engaging hour that sits at the intersection of technology and law, as what would a Future Is Now conference be without a session on AI, right? Our next two speakers will delve into the practical uses of AI and how to do so ethically, followed by another virtual town hall discussion. So pocket those questions as they arise for then. To lead off, we have Damien Riehl. Damien's a lawyer and technologist who serves as the solutions champion at VLEX, which owns Fastcase, many of you may be familiar with. Damien, the virtual stage is yours.
Great. Thank you so much, Mark, and thank you everyone for joining me. These are very exciting times. Greetings from a law school where I just was able to speak to a whole bunch of folks to be able to say this is the way the practice of law is going to be changing. I've been a lawyer since 2002. I clerked for a bunch of judges. I worked for a big law firm where I represented Best Buy, victims of Bernie Madoff, also helped sue JP Morgan over the mortgage-backed security crisis. I've also been a coder since 1985. So this is me as a 10-year-old, and this is the Commodore 128 that I used to be able to code back in the day. The number of lawyers that are also big law refugees, that are also judicial clerks that work in technology, there aren't many of us around. So in 2015, I pitched Thomson Reuters. I said, here's legal tech that can change the world. You should build it and hire me. And they were dumb enough to hire me. So I helped lead a team of 100 programmers and 50 lawyers to build this big thing. Left that job to do a cybersecurity job where Facebook hired me and my company to investigate Cambridge Analytica. So I spent a year of my life on Facebook's campus with Facebook's data scientists and my former FBI, CIA, NSA people figuring out how bad guys use Facebook data. During that time, I did a project that I've given a TED Talk that's been seen 2 million times, where I've copyrighted 471 billion melodies, every melody that's ever been and ever can be, and we'll talk about that some other day. But this guy thinks that I rock. My buddy said that Elon has horrible judgment in all areas except for one. This one he actually got right. These days, my day job is with VLEX, where we have 1 billion legal documents with a B. That is cases, statutes, regulations, not just in the United States, but worldwide. And I'm running large language models across those. And I also help lead the SALI Alliance. So I do lots of things, and including helping the Minnesota State Bar Association determine whether or not AI is or is not the unauthorized practice of law. We're also working through the question of whether AI might be able to help the access to justice gap, the 92% of legal needs that are unmet, and our report on this and how AI might be able to help should be due in the coming weeks. I'm also helping the ABA in certain areas as well. So we're, of course, all here to talk about AI and what it is that matters less than what you can do with it. In December of 22, GPT 3.5 beat 10% of humans on the bar exam, whereas GPT 4 only a few months later beat 90% of humans on the bar exam. That's why we're talking about this. By the way, GPT-5 is coming out, rumored in the next few weeks. So how many more will GPT-5 beat than 90%? This guy thinks that AI might be able to help access to justice, being able to give answers to basic questions and maybe take that 92% and shrink it down. Large language models are solutions, tools to problems. But we often think of them in this order when we should be thinking about what are the problems that we want to solve and what are the tools that we want to solve them. And large language models these days are pretty good tools to solve many problems. Those problems are, I want AI to blank. What fits in the blank? It turns out that large language models might be able to help those problems. When I was a litigator, I would create counter-arguments and good facts. So I took an actual lawsuit where a bunch of coders have sued Microsoft and OpenAI over ChatGPT, where the coders uploaded a bunch of code into GitHub, and then Microsoft ingested that code into GitHub Copilot, and AI created a tool. And the coder said, hey, wait, all of that is MIT licensed. So by ingesting it, you breached our contract. So this is a real lawsuit that I thought it'd be fun to have ChatGPT argue against its owner, OpenAI. Here's OpenAI's motion to dismiss. And so I said, hey, ChatGPT, here's a motion to dismiss, create counter-arguments against them. And here is a list of counter-arguments, saying things like standing. OpenAI said that the coders lacked standing, but ChatGPT said, no, they have concrete and particularized injuries that are linked to defendant's actions. Then I said, okay, for each of those claims, give me the elements of those claims. And they said, to show standing, you have to show injury, causation, and redressability. These are all the proper non-hallucinated elements of those claims. Then I said, give me some facts to prove each of those elements of each of those claims. And it did that for every single claim, saying, to show standing, you might be able to show that the platform decreased the market demand for my coding, that injury in fact is direct economic harm, causation is a downturn in sales, and a court injunction will provide that redressability. That is a good legal argument. Another good legal argument saying, hey, what if the coders lost a major client because they used GitHub Copilot instead? That shows injury in fact. And causation, that's great because they switched to OpenAI's product, which is similar. And of course, monetary damages from the court might be able to help. That is a good legal argument. Now create a questionnaire to ask the coders questions that will help them win. And here are some questions for the coders. Can you show economic loss? Can you quantify it? Can you show documents? These are good questions to be able to ask your client. Give me a direct link, like dates. Can you say when your downturn in sales happened so I can link that to OpenAI's launching of GitHub Copilot? That is a good legal argument, good facts to be able to have. All of that took me less than a minute. So the question is, how long would that have taken an associate to be able to build? And if they charge $500 an hour, maybe it would have taken 8 hours. And how are you going to charge for 45 seconds of prompting? And what if it's not even going to take 45 seconds? What if you have access to 1 billion legal documents worldwide, and instead of 45 seconds, you're actually baking it into the legal software? And that's what I'm doing today. We've talked about the death of the billable hour for decades, and it hasn't happened. And I still don't think the billable hour is going to die. But what I think will happen is the current percentage of work that is flat fee will rise from 10% to 20% to 50% to 80% to 90%. There will be more flat fee billing and less hourly billing. It's inevitable. It's just a matter of when. When I was a litigator, I would find logical inconsistencies. And so I said, here, give me Microsoft's and OpenAI's logical flaws. And it said, where OpenAI said, you as coders don't have legal interest to restrict the study of the code you put on the internet. That's a good argument. But then ChatGPT created the counter argument, saying that implies by making it freely available, the coders relinquish their legal interest. But that's not true. They attached the MIT license, terms and conditions. That is a good counter argument. Then where OpenAI said, hey, you didn't say which of the 6 OpenAI entities did what things, then it should be dismissed. And OpenAI responded, well, listen, these are joint actions of the same corporate family. We can refine this specificity through discovery. This shouldn't be a motion to dismiss. That is a good counter argument. Now, tell me facts of how plaintiff coders could be able to say breach of contract claim on a large language model could violate the license agreements. And here you could, this still blows my mind. It says the injury in fact, you could argue, to show standing, could be the breach of contract itself, because it's through that breach of contract that the coders lost control of the code, and they intended to retain that through the MIT license. Now, that is a good argument that I wish I, as a 15-year litigator, would have thought of, but I'm afraid to say I would not have thought of that. In fact, I even thought, is this a hallucination? Is this actual law, or is this just made up? So I asked my tool. I said, to show standing, can the contract breach itself be the injury in fact? And here it said, yeah, here's a Vermont case saying that a breach of contract is a concrete injury for Article 3 purposes. Then I clicked on Patel, and in Patel, they gave me a bunch of other cases that said, yes, breach of contract is a concrete injury for Article 3 standing. This is an ideation machine, and this is grounded in truth. These are actual non-hallucinated cases with actual non-hallucinated text. People that say, it's not quite there yet, they haven't really asked question number 2 or question number 5 or question number 20. So I said, I like ChatGPT that you said the injury in fact is the breach of contract itself. Expand upon this. And here they said, yeah, here's the MIT license saying that, that OpenAI and Microsoft need to attribute the code to the coders and that they can't use it commercially. These are good legal arguments. That is an ideation machine. When I was a litigator, and even before that, when I was in law school, my law professor would say, if you want to understand a statute, put it into if-then statements. If this thing happens, then this is the result. And so I took a random statute, happens to be New York statute for falsifying business records. Maybe a former president might have been charged by it. And I said, take this statute and put it into if-then statements. And here's the output. If someone falsifies business records and intends to commit or aid and conceal another crime, then Class E felony. Now look at what's on the left, and then look what's on the right. And I will ask you 3 questions. Question number 1, which is easier for you as a lawyer to read? The question number 2, which is easier for a client to read and understand? And then number 3, which is easier for a computer to understand? Because computers work in if-then statements. So what if you were to have access to, hypothetically, 1 billion legal documents? That is every case, statute, regulation, not just in the United States, but worldwide. And we're to run every single one of those through a large language model to get the answer output like this. Wouldn't that be fun? Are we on our way to computable law? Then I said, argue that Donald Trump violated the elements above. And here's the output, saying that if Trump intentionally committed a false entry in business records and intended to commit another crime like tax fraud or money laundering, or aid and conceal another crime like insider trading or bribery or campaign finance violations, then guilty of a Class E felony. This is the beginning of computable law. I'm in Minnesota, greetings from Minneapolis, where I thought it'd be fun to say, when will Purple Rain be in the public domain? And I, by the way, uploaded the copyright statute on the duration of copyright. And it said, well, Purple Rain, Prince died in 2016. The copyright statute says life of the author plus 70 years, which is 2086. But it doesn't end in that calendar year. It actually goes to the next calendar year. So the answer is January 1 of 2087. That is the right legal answer. You can imagine if you are a client, option 1 is to be able to ask your friendly lawyer this question. Option number 2 is to ask your friendly large language model this question. Option 1 lawyer is never going to know why the phone stopped ringing. Then I followed up by saying, how about What a Wonderful World? Nothing more than that. How about What a Wonderful World? And they said, these are actually co-songwriters. And in joint work, it goes by the last surviving plus 70 years. The last surviving guy died in 2010, so 2010 plus 70 equals 2080. And again, it doesn't end then. It goes to January 1 of the next year. And that is the right legal answer. This is a reasoning machine. A friend of mine is a privacy lawyer. She said, you're never going to be able to do a privacy playbook like I do for my California clients. And so we sat at my kitchen table and I said, you're a retailer building a privacy playbook under California law. And she said, my God, this is everything that I would go through. She said, what data are you processing? Why are you processing it? Who's receiving it? Are you minimizing data? Are you dealing with GDPR? Also, if I'm a data subject, can I access my data, delete it, opt out? These are all things I would go through with my clients. Then I followed up by saying, give me 3 examples of how a retailer in California will implement each of those bullet points. And here's a whole bunch of answers saying, hey, for types of data, you might be collecting names and addresses for loyalty programs. You might be collecting purchase history for marketing. You might be collecting web browsing data for personalized content. She goes, these are all the things that I would be doing with my clients. This is an actual lawsuit. This little girl, Falana, had been burned by a bunch of chicken nuggets. But this is a fictionalized interview with that girl. So I said, here's an interview, draft a complaint and put these in the facts and the claim sections. And the output looks like this. It said things like McDonald's had a history of serving excessively hot food, and it was unsafe and unnecessarily high. Here are all the bad things that happened to my client. And defendants owed a duty of care, and they breached that duty. These are the elements of negligence. Is this what I would file with the court? No way. Is this way better than a first-year associate can do? And did it give it to me in seconds? Yes, indeed, it is. In 1 minute that I have left, if I'm a jury consultant, I'd be worried, because here are a whole bunch of good jury questions. Here are a whole bunch of bad answers for the jury questions, and here are a whole bunch of good answers to the jury questions. These are a way that you could be able to do your work much faster, much better, much stronger. You could be able to do motions to dismiss. And of course, you could also, because people like it in Microsoft Word, this is what it looks like in Microsoft Word. Microsoft is baking this into Word. Google is baking this into Google Docs. This is the air that we breathe. And this is a way, if you were to say, is Microsoft committing the unauthorized practice of law by baking this into Word? What bar association is going to sue Microsoft, which is the biggest market cap company in the world? Who is going to sue Microsoft and their throngs of lawyers? Who is going to sue Google and their lawyers? Who is going to sue Facebook, Meta, and their lawyers? This is something that is going to be like the air that we breathe. And these are just a few of many, many examples of ways that we can be able to take the practice of the law and think, what do I as a lawyer do? And it turns out that I as a lawyer and you as lawyers, we do 3 things. We ingest words, we analyze words, and we output words. And it turns out that large language models are able to do all 3 of those things at superhuman speed and at a postgraduate level. Today, it beat 90% of humans on the bar exam. That's GPT-4. And OpenAI is baking GPT-5 right now. They're rumored to have it being released in maybe a few weeks. So if it beat 90% of humans today, how many humans is it going to beat tomorrow? And for the people that say, well, the bar exam is not the practice of law, I agree. But I would say how much of the work that we as lawyers give to our, charge our clients for are actually easier than the bar exam. And that's the reason why we're talking about this today, is that we could be able to not only make the practice of law better, that is, we could do more of our work thinking and less of our work thunking, that is the drudgery of the work. Nobody likes doing initial research. So if we can take that 10-hour task and shrink it down to 2 minutes, that is more time for thinking and less time for thunking.